In the 1984 case Chevron USA versus Natural Resources Defense Council, the United States Supreme Court held that federal courts must defer to federal agencies' reasonable interpretations of ambiguous statutes that the agency is responsible for implementing. Nearly 20 years later, in Christensen versus Harris County, the court considered whether an agency's interpretation of its statute, which appears in an opinion letter, is entitled to Chevron deference. Under the Fair Labor Standards Act of 1938, or the FLSA, states and their political subdivisions may compensate their employees for overtime by giving them time off, or comp time, instead of overtime pay. Additionally, the FLSA provides that employers must accommodate requests for comp time if comp time wouldn't, quote, unduly disrupt the employer's operations, unquote. But the FLSA doesn't state whether employers can require their employees to use comp time. Concerned about being able to pay for their employees' overtime, Harris County, Texas, sought to adopt a policy requiring their employees to schedule comp time. To make sure that the policy was permitted under the FLSA, Harris County wrote to the United States Department of Labor, or the DOL, which is the agency in charge of implementing the FLSA. The DOL responded in an opinion letter stating that an employer can require its employees to use comp time under the FLSA if the employees agree to the practice in advance. Consequently, Harris County implemented a policy that allowed supervisors to require their employees to use comp time. Subsequently, deputy sheriffs, including Edward Christensen, sued Harris County in the United States District Court for the Southern District of Texas for violating the FLSA. After filing suit, Christensen and others moved for summary judgment, believing that they were entitled to judgment as a matter of law. The court granted the motion, and Harris County appealed to the Fifth Circuit, which reversed, holding that the FLSA was ambiguous and didn't prohibit the county from implementing its comp time policy. The United States Supreme Court granted cert.